Thank you for joining us today. If this is your first time joining us, welcome. I hope you enjoy it. And if you are returning, thank you for coming back. Today we have a great presentation for you from one of our steering committee members, Mansoor Ali. However, before I hand over to him, I will jump right in with a brief introduction of the ICCP. Okay, so who are we and what do we do? The Institute of Construction Claims Practitioners is a professional members organization. We exist to recognize those with the skills, qualifications, and expertise in the professional management of construction claims. We have three primary objectives, which are to establish international standards, to give recognition to those who have achieved those standards, and to help and educate those who would like to gain experience in the management of claims and do so to the highest level of professionalism. And why is there the need for the ICCP when there are so many construction organizations? Well, quite simply, construction claims have become a key part of the international construction industry. And our professionals come from a variety of backgrounds within construction, from engineering, quantity surveying, project management, even construction law. And along the way, they have moved into claims and they deserve recognition. But until the ICCP was established, there was no institute that specifically recognized claims practitioners for their specialist knowledge, experience, and skills. Okay, I will briefly introduce that we have an elected steering committee. We have 5 elected members from the fellows. We have 5 elected fellows from the membership body, as well as our executive officer, Andy Hewitt, and our elected president, Paul Gibbons. And in terms of membership, I won't go into detail. I will let you know that we have 3 levels of regular individual membership that each have their own criteria, as well as the special levels of student member and graduate member for those who are either studying for a primary qualification in construction or who have just completed their first degree. We also have corporate membership for companies and departments that specialize in construction claims. And what is in it for you? Well, we have a private members area of our website, which has a collection of research, white papers, case studies, etc. in our knowledge bank. We have a template library to help our members both save time and ensure that they are completing their claims to the highest degree of professionalism. We have regular CPD opportunities like this one. So this webinar is free and open to the public, but only members will get a CPD certificate. We also have the ICCP Academy, which are more technical sessions, which are only open to members. We have training and book discounts through Wiley Blackwell and Rutledge, as well as our training partner Claims Class. We also have a monthly members newsletter to keep our members up to date on the latest happenings around the industry. We offer industry exposure in the form of a public listing of our members, as well as the usual benefits of a logo and certificate of membership. We also have a private LinkedIn group where our members can ask their claims and contracts questions in a confidential setting and get the advice of their fellow members. We have the optional benefit of the Register of Claims Practitioners, which is a popular option with our consultant members. And we also have an annual conference. Last year was our first conference. And this year we will be having our second conference. This year it will be a full day of learning on September 25th from 9 to 6. And that will be free to members. It is currently £60 for the early bird rate for non-members. However, if you use the code webinar275, you will save an additional £10. And once the early bird period has ended, that will go up to £80 for the full registration fee. And I know that I said all of that very quickly. If you requested additional information when you registered for this session, you will be getting an email in the next few days that will have additional information. Additionally, you can visit our website, instituteccp.com, or you can email Paulina Ganova at paulina.ganova@instituteccp.com. Okay, that was very quick. Someone has raised their hand. Could you send me a message and I will answer it in the chat. For anyone else, if you do have a question during the session for Mansoor to ask during the Q&A period, please do put it in the Q&A box rather than the chat box so it doesn't get lost. And with that, I will hand it over to Mansoor, and he has let me know that he is currently in the middle of some extremely inclement weather. So if anything happens, which we hope it won't, it is beyond his control. All right. Mansoor, welcome, and thank you very much for joining us today.
Thank you. Thank you so much, Jennifer. Wonderful start as always, And it's great to be speaking to the ICCP platform after a year-long gap. I'm quite thrilled to see the huge amount of participation today, and I hope that I make this topic somehow interesting. A bit of more introduction about myself, although Jennifer have done it. I'm a FIDIC affiliate member, as well as the member of their newly formed committee, IFIC. I'm also a fellow in ICCP and their steering committee member. So I hope the screen is visible to all by now.
We are not looking at the slideshow view, though. We are looking at the full screen view.
All right, now here you go. So this
there you go. Yeah, perfect.
Wonderful, thank you. All right, so now let's start with the webinar on notice in Gold Book 2008 edition. You must all be knowing that the Gold Book is a FIDIC standard particularly suited for design, build, operate projects where the design, construction, and operation of a facility are procured from a single contractor. One key aspect of this Gold Book is the notices, which is similar to all of the FIDIC contracts and defined under subclause 1.153 and governed by subclause 1.3. Notices are formal communication that trigger various contractual rights, obligations, and procedures. So on to the definition of the notices as stated in 1.153. Notice is a written communication, specifically intended as such and used in accordance with the guidelines outlined in subclause 1.3. There are over 70 subclauses requiring one party to give notice to the other party regarding some occurrence, which may have some implication and give for the right of payment or time extensions. Now we move into subclause 1.3, which defines notices as a form of communication which shall be so identified and include reference to the clause under which it is issued. And it shall be in writing, delivered in the mode and address as stated in the contract data. And if the recipient gives another address through a notice, then notices or communication shall be so delivered there and otherwise from where the request was issued, without unreasonably withholding or delaying them and copying all parties. All right, now we move into notice provisions within the 20 FIDIC clauses, and starting with general provisions, clause number 1. So subclause 1.9, care and supply of document. If a party notices any kind of technical error or defect in the document while executing the work, the party shall promptly give notice to the other party. And subclause 1.10, error in employer's requirements. If an error or an issue is discovered in the employer's requirement at any time, immediately the contractor shall give a notice to the employer's representative detailing the nature of the error and requesting instructions of rectification. And upon receipt of such notice to on employer's requirement, which was supposed to be scrutinized by an experienced contractor, and if it was not possible for an experienced contractor to have scrutinized, he provides a notice, and in such case, employer representative assesses whether an experienced contractor should have discovered such an error and specify the extent of the errors. And if the contractor incurs delay or cost due to it, then the employer representative is bound to grant such extension and cost plus profit. Moving to notices under the employer now. Clause number 2, subclause 2.1, right to access to the site. If the contractor faces delays or extra costs due to the employer's failure to provide access on time, he shall give notice to the employer representative, who then shall proceed to agree or determine the matters. If the employer's failure was due to an error or delay by contractor, including issues with the contractor's document, the contractor won't be eligible for an extension of time or additional payment. Now on to subclause 2.4, employer's financial arrangements. If the employer intends to make any material change to the financial arrangement or has to do so because of changes in the financial or economic situation, he shall give notice to the contractor with detailed particulars. Upon the contractor's request, the employer must provide reasonable evidence within 28 days to show they have secured and maintained the necessary financial arrangement to pay the contract price. All right, so now we move into clause number 3, the employer's representative, and explore the notice provisions within that clause. Subclause 3.4, replacement of the employer's representative. If the employer intends to replace the employer's representative, he shall give notice not less than 42 days before the intended replacement date. However, if the contractor raises a reasonable objection by notice to the employer with supporting particulars, the replacement shall not proceed. And subclause 3.5, determination. If a matter occurs, the employer's representative initiates consultation, and if agreement is reached, it is recorded in a notice. If not, the employer's representative issue a notice of determination based on the contract and all relevant circumstances. All right, now we move on to notices under the contractor, which is clause number 4, contractor's representative, subclause 4.3. If the contractor has not proposed a contractor's representative in the contract, he may do so before commencement date for approval with a notice to the employer's representative specifying the delegations. Now on to subclause 4.4, subcontractor. If subcontractor is not named in the contract and contractor intends to subcontract part of the works, the contractor shall provide at least 28 days notice before the intended date of subcontractor's work on site for the approval of the employer's representative. Now we move into subclause 4.5, nominated subcontractor. While this clause allows the employer to be having nominated subcontractor within the contract, contractor shall provide notice to employer representative with supporting detail as soon as possible if they have reasonable objection to hire a nominated subcontractor. Now we move to subclause 4.7, setting out. If the contractor experienced delay or incurred cost due to error in this reference point that an experienced contractor could not reasonably have discovered, then they shall immediately notify the engineer representative according to that. And the engineer representative shall then verify the intensity of it through his determination clauses and apply subclause 20.1 contractor's claim for an extension of time or cost as the case may be. We now move to subclause 4.12, unforeseeable physical condition. If the contractor faces adverse physical condition that are considered unforeseeable, he shall promptly give a notice to the employer representative, who then moves to determination and the contractor's claim as the case may be. Subclause 4.16, transport of goods. Contractor shall give notice to employer's representative at least 21 days before delivery of plant or good to the site, and in such case, the employer shall make appropriate arrangement to receive them. Subclause 4.20, employer's equipment and free issue material. While this subclause allows employer to make the employer's equipment and free issue material, if any, available for the use of the contractor, contractor shall issue notice promptly to employer representative if contractor, after visual inspection, identifies any shortage or defects or issue in this material, and employer shall immediately address the reported issue. Subclause 4.24, fossils. Contractor shall promptly give notice to the employer's representative if he discovers fossils, valuable item, archaeological findings, or historical structures on the site, and thereafter, employer representative provides instruction for handling the discoveries. Now we move into subclause 4.26, subclause 4.25, change in contractor's financial situation. Contractor shall immediately give notice to the employer with detailed particulars if he becomes aware of any changes in their financial situation. Within 28 days of receiving such notice, the employer shall advise the contractor to determine the necessary action. That was clause 4, contractor. Now we move into notices under design. I know it must be a little tough topic to many, but all I can assure is that we are almost done quarter of the webinar. And please bear for the remaining part with time now to ponder more into the notice provisions under the design clause. So subclause 4.5.1, general obligation, design obligation. If the contractor identifies error or defects in the employer's representative, he shall give notice to the employer representative instantly, and the employer representative shall determine whether clause 13 variation and adjustment shall be applied and shall give notice to the contractor accordingly. Subclause now 5.2, contractor's documents. If the employer's requirements specify certain contractor's documents need to be submitted for review or approval, the contractor shall submit accordingly together with a notice. Now, this document, the employer representative shall review whether it confirms, approved, or it does not, and accordingly shall give a notice stating the same within the review period. Subclause 5.4, technical standards and regulations. If there are changes or new applicable standards come in effect after the base date, then the contract shall give notice to the employer representative, and the employer representative determines that compliance necessary and the proposed measure for compliance, and if it constitutes a variation, they shall initiate a variation in accordance with clause 13 variation order. Now we move to notices under plant, materials, and workmanship. Subclause 7.1, 7.3, inspection. Contractor shall give notice to the employer's representative if any work is ready for inspection before it gets covered, concealed, packaged for storage, or transported. The employer's representative shall then either conduct an examination, inspection, measurement, or testing without unreasonable delay, or promptly give notice to the contractor that such actions were not required. Subclause 7.4, testing. If the employer's representative initiates to attend the test, he shall give notice to the contractor not less than 24 hours prior to the test. And if employer representative doesn't appear, the tests are considered to have been conducted in the presence of the employer's representative, unless otherwise instructed by the employer's representative. Moving into subclause 7.5, the rejection. The employer's representative may reject the plant, material, design, or workmanship if found to be defective or not in accordance with the contract by giving notice to the contractor with reasons. Contractor shall then rectify the defect and ensure contract compliance at his cost. Now we move to notice provisions in clause 8, commencement date, completion, and program. Subclause 8.1, commencement date. The employer's representative shall give notice to the contractor at least 14 days prior to the commencement date. Commencement date shall be within 42 days after the letter of acceptance, unless stated otherwise in the particular conditions. Now, subclause 8.3, program. After receiving the notice under subclause 8.1, detailed time program within 28 days time to be provided. And if employer representative doesn't give notice on this for a revised program submission within 21 days after receiving the program, the contractor is to proceed with the project according to that program. However, if the employer representative later gives notice that the program doesn't comply with the contract or align with actual program and intentions, the contractor must revise the program within 14 days and resubmit it. I'm sure you must have started yawning by now. Let me try to change the style and tune of the presentation with a video session now. Please bear with me a few seconds until I shift the presentation to the video. Just a minute. Let me close this And let's move into the video session now, where we will be explaining the clause number 9 and 10. So here you go. Yes, please.
Subclause 9.1, Commencement of Design Build. Commencement date is determined by giving a notice under subclause 8.1, Commencement date, and contractor must begin the design build activities within 28 days of receiving this notice. Subclause 9.3, Extension of time for completing design build. If the contractor considers entitled to an extension of the time, he shall give notice to the employer's representative in accordance with subclause 20.1, contractor's claims, and a separate notice under the same subsections. If additional costs have been incurred due to the delay, employer's representative then proceed with determinations and may increase, shall not decrease, the total extension of time. Subclause 9.8. Consequences of suspension. If contractor experiences delays or incurs costs due to complying with it, employer's representative's instructions under subclause 9.7, suspension of work, or resumes work after suspension, then the contractor shall give notice to the employer's representative on A, an extension of time for any such delays. If completion is or will be delayed under subclause 9.3, extension of time for completion of design build, and B, payment of any such cost, which shall be included in the contract price. Subsequently, employer's representative shall proceed in determination. Subclause 9.10, prolonged suspension. If a suspension of work persists for more than 84 days, the contractor may request permission from the employer's representative to resume work. If the employer's representative does not give permission within 28 days after being requested to do so, the contractor may give notice to the employer's representative under clause 13, variations and adjustments of the affected part of the works. And if the suspension affects the whole of the works, the contractor may give notice of termination under subclause 16.2, termination by contractor. And now moving on to notice provisions in clause 10, operation services. Subclause 10.4, delivery of raw materials. The contractor shall be entitled to give due notice to the employer if any item or product is not delivered in accordance with the agreed delivery program or deviates from the specified quantity with the nature of the cost which he has incurred, then the contractor is entitled to recover his cost plus profit if the delay or deviations cause him to suffer additional cost. Subclause 10.6, delays and interruptions during the operation service. The employer's representative may instruct the contractor to suspend the progress of the operation service, and if such suspension is not due to failure by the contractor nor to circumstances for which the contractor is responsible under the contract and has continued for more than 84 days, the contractor may request the employer's representative's permission to proceed. If the permission is not granted within 28 days, the contractor may give notice of termination under subclause 16.2, termination by contractor. Subclause 10.7, failure to reach production outputs. If the contractor's failure to achieve the required production output continues for a period of more than 84 days, then the employer may either continue with the operation service at a reduced level of compensation determined in accordance with subclause 3.5 determinations, or if the production output fails to reach the minimum value required in the contract data, give notice to the contractor not less 56 days prior to terminating the contract in accordance with subclause 15.2, termination for contractor's default.
I'm sure this video presentation would have made you all awakened. In fact, this whole topic was presented through 10 parts and published in LinkedIn. And I'm sure, many of you who are participating here must have seen those videos. But anyway, ICCP will be now republishing them again. So those who would love to be part of that, please join there again. And let's move on, continue with the rest of them. Those who are bravely staying back, thank you so much, and hope you remain till the end of this webinar. Now, just a minute, I'm just changing this styles again. All right, now we move into the notice provisions in clause 11, which is testing, and through my normal presentation instead of the video. So subclause 11.1, testing of works. The contractor shall give notice to the employer's representative not less than 21 days before the scheduled date of required specific test. During the trial operation, the contractor shall give notice to the employer's representative when the works are ready for any other required test. Upon passing required test, the contractor is required to submit a report to the employer's representative as evidence of completion in line with subclause 9.2, time of completion. Now, subclause 11.2, delayed test on completion of design build. The employer's representative may, by notice, require the contractor to conduct the test unduly delayed by the contractor. The contractor shall carry out the test within that period and shall give notice of the scheduled test day or days to the employer's representative within 21 days after receiving the notice. If the contractor fails to conduct the test within the specified 21 days, the employer's personnel may proceed with the test at the contractor's risk and cost. Subclause 11.4, failure to pass test and completion of design build. If works or a section of the work fail to pass the test and completion repeated under subclause 11.3, the employer's representative shall be entitled to either repeat the test once more or issue a notice under subclause 15.1, which is notice to correct. If the contractor does not or cannot correct the fault, the employer can, if so he wishes, terminate under subclause 15.2. Now we move to subclause 11.5, completion of the works and sections. The contractor may apply by notice to the employer's representative 14 days before the contractor believes the work or section will be fully completed and ready for commencement of the operation service period. For commissioning certificate purposes, employer representative to issue the commissioning certificate to the contractor or reject the application, giving reason and specifying the works required to be done by the contractor. The contractor shall then complete the work before issue further notice under the subclause. Moving to subclause 11.9, procedure for test prior to contract completion. The employer shall give notice to the contractor not less than 21 days before the specified date for conducting the test prior to contract completion. The contractor shall carry out the test within 14 days after the specified date determined by the employer's representative. And after the successful test, the contractor informs the employer representative that the works are ready for final inspection. And once the employer representative is satisfied with the final inspection, they notify both the employer and contractor prior to the issue of the contract completion certificate. Now to subclause 11.10, delayed test prior to contract completion. If the contractor fails to commence the test on the day or days determined under subclause 11.9, which is procedure for test prior to contract completion, the employer's representative shall give notice to the contractor. We're moving on to subclause 11.11, failure to pass test prior to contract completion. The contractor may be instructed by himself or by the employer representative that access to the works or section cannot be given until a time convenient for the employer. The contractor shall remain liable to carry out the adjustment or modification and satisfy this test with a reasonable period after receiving notice by or on behalf of the employer of the time that is convenient to the employer. If the contractor does not receive the notice during the relevant contract period, the whole of section shall be deemed to have passed the test. Now we move to notices under defects, which is clause 12. Subclause 12.3, failure to remedy defects. If the contractor fails to remedy any defects or damage occurred during the design, build, or operation service period, a date for remedying the defect or damage may be fixed by the employer representative, and the contractor shall be given reasonable notice of this date. If the contractor fails to remedy the defect or damage by such date, they are subject to subclause 12.2, cost of remedying defects. And in such case, the employer or through his employer's representative determine and certify a reasonable reduction in the contract price or operation service period rate, and as well as if the defect or damage prevents commissioning of the works or the operation service, the employer can terminate the contract for such part of the work in accordance with the provisions of termination by employer clauses, requiring all payments and incurred cost. Now we move into subclause 12.4, failure, further tests. If any defect or damage may affect the work performance, the employer's representative may require the repetition of any of the tests described in the contract by giving notice within 28 days after the defect or damage is remedied. Now we move to clause 13, variation and adjustment, and we will discuss the notice provisions within this clause. So subclause 13.1, right to vary. The employer representative may instruct or order a variation at any time during the contract period, and the contractor is obliged to comply with those instructions. Unless he has a valid reason, including inability to obtain required material, safety concern, and adverse effect on guarantee, then he shall provide written notice with details of their reason. And in such a case, the employer representative shall cancel, confirm, or vary the instruction based on the contractor's notice. Now we move to subclause 13.6, adjustment for changes in legislation. A change in legislation always brings in a variation, no doubt about it. But either party can request adjustment to comply with the change in law by providing written notice. It could affect the contractor, it could affect the employer as such. And in such case, after getting the notice, the employer representative goes for the determination and determine and agree these matters. Similarly, subclause 13.7, adjustment for change in technology. If the contractor is asked to change, if the contractor is asked to bring in a change in technology, new material or products that the contractor is obliged to adopt, then the contractor, through subclause 20.1, issues a notice and requests for an extension of time or cost. And after getting such a notice, the employer representative shall move into determination, which is subclause 3.1, and issue a variation to the contract with details of the required change, if so mandated. Now we move into notices under contract price and payment, which is clause number 14, contractor's payment and price and payment. Subclause 14.7, issue of advance and interim payment certificate. If the payment certificate amount is less than the minimum amount stated in the contract data, employer representative shall give notice to the contractor. However, if the employer representative refuses or fail to issue a certificate after receiving a proper application from the contractor, he may, after giving 21 days notice and receiving a proper application from the contractor, he must, after giving 21 days notice, and suspend the works under subclause 16.1, contractor's entitlement to suspend work, and may terminate the contract if the delay exceeds 56 days after receiving the payment application. So we are just going only on the notice provisions in these clauses here. And moving on to subclause 15.5, 14.9, delayed payment. Contractor is entitled to receive financing charges if he does not receive payment in accordance with subclause 14.8 payment. Such contractor's entitlement to financing charge is automatic and does not require formal notice, subject to providing evidence of the delay in the form of either a statement or the employer's representative payment certificate. Now we move to subclause 14.18, which is asset replacement fund. If contractor intends to replace any item or plant identified in the asset replacement schedule, he shall give notice to the employer's representative at least 28 days before the planned replacement of the item. And the contractor in this case is not required for an approval from the employer representative because the notice helps align actual and planned replacement date And if the chosen date isn't suitable, the employer's representative can instruct a delay. Now we move to subclause 14.19, maintenance retention fund. If required, maintenance under the contract has not been performed, the employer may, after giving due notice to the contractor, carry out such maintenance using available maintenance retention fund. And if the funds are insufficient, any outstanding cost will be offset against payment due to the contractor, or if no payment are owed, become a debt owed to the contractor by the contractor to the employer. That ends the clause number 14, and now we are going into some serious clauses. To start with is clause number 15, which is termination by the employer. Subclause 15.1, notice to correct. If the contractor fails to carry out any obligation under the contractor, employer's representative issues notice to correct, and contractor is to make good the failure and to remedy it within the time specified in the said notice. Moving to subclause 15.2, termination for contractor's default. Employer can terminate the contract due to contractor's default by giving contractor 14 days notice if contractor rectifies the failure. The notice is deemed to have been withdrawn, and if not, the termination will become effective, and he must leave the site and hand over all goods, contractor's documents, etc. to the employer. If the contractor engages in bribery or other inducement related to the contract or failed to complete the design build within the cutoff date of 182 days after the time for completion of design build, then the employer may by notice terminate the contract immediately. We now move into subclause 15.3, valuation date of termination for contractor's default. Now that we already explained about what constitutes a contractor's default, upon a contractor's default and a termination is given, the notice provisions on the valuation date of termination is as detailed. So soon after the 15.2 notice of termination is provided, the employer representative shall proceed with the termination process as per subclause 3.5 to agree or determine the value of the works, goods, and contractor's document and any other sum done by the contract in accordance with the contract. Now also the payment after the termination for contractor's default, subclause 15.24. So after the 15.2 notice of termination due to the contractor's default, the employer representative is entitled, the employer is entitled to recover from the contractor all cost, losses, and damages incurred or suffered by the employer as a result of the termination under subclause 15.2. Now, moving on to subclause 15.5, termination for employer's convenience. If the employer rejects to terminate, elects to terminate the contract at any time for reasons other than those specified in 15.2, which is the termination for contractor's default. So if the employer is terminating for any other item which is not due to contractor's default, then the employer shall issue a notice and immediately return the performance security to the contractor. The termination shall affect 28 days after receiving the notice or the performance security to the contractor. And upon issue of the notice, the employer shall no longer be allowed to use any of the contractor's documents and shall promptly return all contractor's documents to the contractor. Moving to subclause 15.6, valuation at the date of termination for employee's convenience. Now through 15.5, when the employer terminates for convenience, then based on which notice of termination has been provided, then the employer representative shall proceed with determination to determine the value of works, goods and the contractor's documents and other sum due to the contractor for work executed as per the contract, which was caused due to the termination for employer's convenience. That was all for the clause 15. Now we are moving into clause number 16, which is the termination by contractor. I hope you all are still around. I'm just looking into the, it all looks good. Thank you for continuing here. And we are almost on the third part, last part of this session. So very close to the curtains of this webinar on Notice in FIDIC Gold Book 2008 edition. And looking forward for you all to continue till the end of the session. Now we move into notice under termination by the contractor. So clause 16, subclause 16.1, contractor's entitlement to suspend. Contractors entitled to suspend due to non-payment, delay in payment and all those things. But he has to give a timely notice to the employer. If the contractor suffers delay and or incurs cost due to suspending the work because of these reasons, then the contractor shall give notice to the employer's representative subject to an extension of time for such delay and payment of any cost plus profit. An employer representative shall proceed with determination. Now, subclause 16.2, termination by a contractor. Like any other FIDIC form, contractor can terminate if all these conditions are met, like substantial failure by the employer to perform obligation on the contract, employer's failure to comply with contract agreement or assignment, failure to providing timely, reasonable evidence requiring a failure to comply with an employer's financial arrangement, employer's representative's failure to issue timely payment certificate, non-receipt of the amount due under interim payment certificate, prolonged suspension affecting the whole of the work as described in 9.10, the employer becomes bankrupt or insolvent. In all these cases, the contractor has the right to terminate the contract by giving 14 days notice to the employer, unless the employer cures the event or circumstances within the said 14 days. And once this is happening, 16.3 details on the cessation of works and removal of contractor's equipment. So after this notice of termination, and if the employer have not cured the event or circumstances within the 14 days, then the contractor shall cease all further work, except as instructed for safety or environmental reason, hand over paid item and leave the site. Now we move to subclause 16.4, payment on termination. After a notice of termination by the contractor, the employer shall return the performance security, make due payments, and pay to the contractor for any loss of profit or damages resulting from the termination. All right, so getting more closer. Now we move into clause number 17, which is risk allocation, and we will just explore few subclauses which details the notice provisions there. So subclause 17.5, responsibility for care of the works. If the contract is terminated in accordance with the conditions, the responsibility for care of works also ceases from the date of expiry of the notice of termination. Subclause 17.6, consequence of employer's risk of damage. If the damage to the works or other property or goods or contractor's document happen subject to employer's risk, the contractor shall promptly give notice to the employer's representative, rectify the loss and or damages as instructed by the employer's representative. If this is during the design build period, then the contractor shall give a further notice to the employer's representative and shall be entitled to an extension of time and payment. However, if this situation happens during the operation service period, then the contractor shall be entitled to the payment of cost plus profit, but not an extension of time. And we're moving into subclause 17.7, consequence of this contractor's risk resulting in damage. If the event occurs due to the contractor's risk, as stated in subclause 17.2 and 17.4, resulting in damage to work or other property or goods, contractor shall promptly give notice to the employer's representative and rectify the damage at his own cost, because this risk is by the contractor. So that was the notice provisions on the subclause 17.7. Now we're moving into clause number 18, exceptional risks. Subclause 18.2, notice of an exceptional event. Affected party from performing their obligation due to an exceptional event shall give notice to the other party within 14 days after party become aware of the exceptional event. With this notice, he shall be excused performance of such obligation until exceptional event prevents from performing. Now moving to subclause 18.4, consequences of the exceptional event. If contractor is prevented any of his obligation due to exceptional event, of which notice as per subclause 18.2 was promptly given, and the contractor suffers delay and/or cost, then contract shall be given an extension of time and payment of such cost if the event occurs during design build period, and if it occurs, this exceptional event is occurring during the operation service period, then the contractor is liable only for the payment of any cost. Now we move into subclause 18.5, which is optional termination and payment and release. If all works are prevented for continuous 84 days or for multiple period of 140 days due to an exceptional event of which notice was given as per subclause 18.2, then either party may give other party a notice of termination of the contract. Termination shall take effect 7 days after the notice is given, and the contractor shall proceed with subclause 16.3, cessation of works and removal of contractor's equipments. Now we move on to the last subclause of 18, which is 18.6, release from performance under the law. If an event arises outside the contract control of the parties, making it impossible or unlawful for either party to fulfill contractual obligation, upon giving notice to either party, upon giving notice from one party to the other party, entitled release for further performance of the contract. And the amount the employer pays the contractor will be determined in accordance with subclause 18.5, optional termination, payment, and release. Now we move into the last clause of this FIDIC Gold book, where we will review the notice provisions. And this is clause 20, notices under the dispute resolution claims, clause number 20. So subclause 20.1, contractor's claim. If contractor considers to be entitled for an extension of time and not cost, he shall give notice to the employer's representative describing the claim within 28 days after the contractor become aware. Contractor gets no entitlement for delayed notice. However, if contractor considers there are circumstances justifying this late submission, he may submit details to DAB for ruling. And if DAB considers the late submission acceptable, he can overrule the 28-day limit and advise parties accordingly. Following contractor's timely notice or DAB accepting a late submission, contractor shall keep contemporary records at site to substantiate claims and permit employer representative to inspect them and submit copies. Subsequently, a fully detailed claim shall be submitted within 42 days after contractor become aware of the period or the period allowed by DAB. Failure to submit the detailed claim within 42 days will nullify the claim and notice considered no more valid. However, if contractor considers there are circumstances to justify late submission, he may submit details to DAB, who, if accepts late submission, the 42-day time limit shall be overruled. If the claim has a continuing effect, fully detailed claim shall be considered in interim. Contractor send further interim claim at 28 days interval, and a final claim with 28 days after end of the effect. After receiving fully detailed claim, employer's representative shall proceed with determination and give his response within 42 days after receiving the fully detailed claim. If employer representative doesn't respond, either party may consider the claim as rejected. If either party is dissatisfied with employer representative determination, within 28 days, issue a notice of dissatisfaction to employer representative and other party, as in subclause 20.6, which is obtaining DAB's decision. If no notice of dissatisfaction is issued by either party within 28 days, employer representative's decision shall be deemed to have been accepted by both parties. Now we move to subclause 20.2, employer's claim. If employer considers entitlement of payment from contractor under any part of the contract, he or employer representative shall give notice with particulars, and employer representative proceeds with determination. If either party is dissatisfied by the determination from the employer's representative, issue a notice of dissatisfaction within 28 days and thereafter proceed towards obtaining DAB's decision. However, if neither party issues a notice of dissatisfaction within the stated 28 days period, the determination made by the employer's representative is considered accepted by both the parties. Now we move into subclause 20.3, appointment of dispute adjudication board. The DAB shall expire upon the issue of the commissioning certificate unless otherwise agreed and unless there is an ongoing dispute. If a dispute is ongoing, the DAB will expire 28 days after issuing its decision on the dispute. The period allows either party to issue a notice of dissatisfaction. Now on to subclause 20.7, amicable settlements. When the notice of dissatisfaction has been given under subclause 20.6, which is obtaining dispute adjudication board's decision, they have 28 days in which to reach a settlement. If no agreement within the 28 days, the dissatisfied party is free to refer the matter to arbitration under subclause 20.9, failure to comply with dispute adjudication board's decision. And if they do not reach the agreement within the 28 days, the dissatisfied party is free to refer the matter to arbitration under subclause 20.9. So the last subclause of today's webinar, subclause 20.8, arbitration. In the event arbitration is initiated, neither party shall be limited in the proceeding to the evidence or arguments previously put before DAB or to the reason given in its notice of dissatisfaction. Any decision made by the DAB is admissible as evidence during the arbitration. That's been a great long webinar session, and I appreciate those who ever had the courage to stay back all the while. I hope this webinar was equally interesting and educative. Was all possible due to the soft hands of my colleagues Sunita Lewis, Fasna Salam, and Rukaya Mansoor, and the wonderful support from you all, which has been the motivation for me for all these few years of FIDIC works. That's all from me today. And if Jen and Paulina feels that there is still time, we can go through some Q&A. But otherwise, thank you so much. And it was wonderful. Thank you so much.
Well, thank you so much. And thank you to your unseen helpers. Yes, I'll rattle these off as quickly as possible. We do have 9 questions. The first question is about the presentation slides. The presentation slides will be posted with the replays both on the public webinar page and in the member area webinar page as well. That'll be in the next few days. Okay, the first question for you, Mansoor. On a specific note, the time bar in FIDIC has always been a contentious issue with differing levels of application, ranging from common law, strictly applied unless justifiably prevented, to civil law, can still claim under the statute of limitations, which range between 5 to 10 years, depending on the particular civil code, to Sharia law, where it is considered that a rightful claim never expires. What is FIDIC's general position on this?
I'm not in a position to speak about the FIDIC's general position, but all I can say is that, now we talked about this FIDIC version of 2008 Gold Book, but if you look into the FIDIC version of 2017 Rainbow Suit, everything has got a time effect, and everything comes with a deeming effect. I'm not sure whether it goes along with any of the civil laws. For instance, Middle East, it doesn't work at all, because like the questioner have correctly asked, your right of claim never settles, even if you do not do it timely. But that FIDIC doesn't entertain that, and FIDIC puts a time bar to anything and everything. And if within the time bar one doesn't respond back, there is a deeming effect also through FIDIC. But look at the case of Middle East. For example, in Kuwait, I know that such thing doesn't work in the local law at all. A claim is a claim at any given day. So I don't want to go detail into that because it's something FIDIC has to look into it. But then if it is kept so loose, then the engineers will have big, huge headache managing the projects.
Okay, thank you. The next question asks if you can go through clause 6 again. Because we are a bit short on time, I would just ask Rajesh if you could please modify your question to specifically what your question about clause 6 is, and we'll come back to you. So the next question is, would you please share the major departures in the Gold Book from the Yellow Book?
Well, yeah, FIDIC Gold Book is a completely different thing because we are talking about an operation period of 25 years plus or minus few years, So that has, because of that, it brings in so many other clauses in addition to a Yellow Book. Here we talk about the operation services, certification during the operation, payment during the operation. So it is not just the construction period of a DB or design, build, operate, but it's the operation period which gives a huge emphasis on Gold Book. But I think my topic is not on the FIDIC Gold Book by itself. It was on the notices in the FIDIC Gold Book. So I wouldn't go more detail on that, but all I can say is that these are meant for two different type of projects altogether.
All right, fair enough. Okay, we do have quite a few questions on time bars. That seems to be everybody's focus and concern today. So the next one says, the duration of 28 days notice period, is it mandatory that the employer rejects the claim made after 28 days? This is not a logical and fair practice. I believe the UAE law permits that claims need not be waived. What are your views?
Yeah, I think we spoke about this. You see, this time bars are all good in FIDIC, and I don't know how much it will work in different laws, but I have been working in Middle East. It's very difficult to bring in such kind of a time barred claim, like what we said, a claim is a claim at any given day. So I forget it now, I forget it 28 days later, I still, what my rights are. So I don't want to go into that too deep. Yes, people from Dubai, people from Middle East cannot digest this time bar thing.
Okay, all right, thank you. The next question is about termination. For termination due to the default of the contractor, if there is payment found to be due to the contractor after termination, must it be paid as soon as the amount is determined, or is the employer entitled to not make payment until the works are complete, for example, by another contractor?
The termination due to contractor's default, there are certain criteria which means that he's not obliging to the works, he's not taking care of care, so many of such things, So naturally, when he is terminated for default of the contractors, there is a determination which engineer representative have to quickly do it. But that determination would just mean that, what he is entitled to and what has to be also done, part of it. Meaning that if there are some works which, if for instance, a contractor doesn't owe or the employer finally ends up owing more than the contractor because of the default. And I think we spoke about that, the employer's claim also along with it. So I think this has to be read in conjunction with the two clauses together, where the employer's claim has to be read along with the termination of the contractor due to his default.
All right, thank you. Okay, the next question. What is the definition of an exceptional event?
Oh, I think we are moving away from the topic. This is something which everyone should be knowing it. There's so many of them. I think they're classic. There have been detailed certain exceptional events by itself, but there are, in principle, exceptional event is something which stops you from your performance, stops both the parties from doing their performance of the contractual obligation. That is one of that, but there are some details clearly mentioned about what an exceptional event would constitute to. But in short, it says that, if you are prevented from performance of your contractual obligation.
So is that one of the terms that is defined like in a glossary
Yes.
in FIDIC?
Oh,
Yeah.
Oh, yes, very much, very much.
Okay. So if someone is using a FIDIC contract, they can just look in their glossary
Yeah,
and find
yes,
that there.
yes.
Okay, the next question. For clause 20, notices for delay, is the notice required to be given within 28 days of when the contractor becomes aware, or 28 days of should have become aware? Ooh, that's splicing it fine.
No, it's the same thing. No, it says 28 days once he become aware. So now
Okay.
here is the interpretation issue anyway, but at the end, only when you know that there is a problem, I inform it because I also be part of this determination. So it is best that I inform.
Okay, all right, thank you. The next question, is there a time limit for the employer to issue employer's claims? In other words, is the employer not subject to similar time bars as apply to the contractor, e.g. 28 days?
No, employer, I think it was subclause 20.2, if I correctly remember. If employer considers entitlement of payment from contractor under any part of the contract, he or employer representative shall give notice, and employer representative proceeds with a determination. But there, the time bar comes once the employer representative issue a notice. Only once the employer representative issues the determination, if there is a notice of dissatisfaction, the contractor comes out with a timeline. Yes, there is something unfairness here that the contractor has to issue it within 28 days, but employer, he can issue it anytime. There is no time bar for the employer. You're right, yeah, whoever have asked this question.
All right. Okay, the next question. Can the engineer reject the claim if the contractor asks for remedy from the incorrect clause or the exact clause is not referred?
I'm not pretty sure about the question. I'm a little confused. What exactly it means?
So basically, can a claim be rejected on a technicality if it is not presented with the precise clause?
I think we are moving out from notices to claim now. These are two different subjects anyway. But a claim. There are procedures for a claim to be submitted as soon as it is aware, and then the fully detailed claim. And at any time, the details are not. If there is a technical issue in the claim, if it is technical problem, the employer representative have the right to reject it if it is not incomplete, or ask for more clarification. But it's a different topic altogether, so the claim and notices are two.
All right, fair enough. Thank you. What does it mean by clause 14.18 assets management?
Oh, this is a FIDIC Gold Book thing, we're talking about something which is very exclusive for the FIDIC Gold Book, where where we are talking 25 years plus or minus few years of operation period. And at that time, the asset management, there is an asset management fund kept for it. And the schedules, unit rates based on the asset management fund on how to use, where to use, how to use, how not to use it. So the notice provision is what I explained here. However, I think to talk to you more about that, it is very simple, straightforward in the FIDIC Gold Book 2008 edition. One could easily get a copy of that and understand that anyway.
All right, thank you. Someone says they disagree with your answer, but they do not say which answer they disagree with. So not a lot of scope for a good conversation there. Moving right along. If a contractor's initial notice is deemed insufficient, is there an opportunity to cure the defect and still preserve their claim rights?
Deemed insufficient would mean that the notice does not contain details pertinent to the intended purpose, I hope. If that is the case, I don't see a reason why he should not be allowed to come up properly, because this notice goes to the employer representative, and employer representative will have to ask that next question, that what is the basis? This is insufficient or it is rejected. And if it is rejected, that doesn't mean the end of the story. He is always having the right to go back after that. So that should not be a problem.
Excellent. Okay. Does subclause 9.10 prolonged suspension need suspension instructions from the engineer for activation?
Again, I think we are going into the clause, not the notice provision. So, there is a limit I can speak, maybe, I don't know, I'm not supposed to be sharing a copy of the FIDIC Gold Book to all the attendees, but would it be nice if whoever is asking have an idea on the FIDIC Gold Book? Because this points of, I was only trying to get into details of the notice provisions on the prolonged suspension and nothing more than that.
Okay. And along to that point, someone did ask if we could provide copies of the Gold Book, and that answer is emphatically no. Any FIDIC contracts, JCT, NEC, whatever forms of contract, that is not the ICCP's intellectual property. You will have to go to those providers. So if you're interested in getting your very own copy of the Gold Book, you will have to go to the FIDIC website for that. All right. Okay. Next.
I'll lose my FIDIC affiliate membership, if I ever encourage giving a copy.
If you're giving away their intellectual property, yes. Okay. Can a time bar be used by the employer as a fair and reasonable defense, even though it's obvious to everyone that an event has clearly delayed the project?
Again, I think we are moving away from the topic very much. This time bars, it's a topic by itself, and it requires, little bit more seriousness on it, because the time bars, there's so many method of doing it. In 1999, FIDIC suit had some time bar, but very little deeming effect. In 2008, it is more of a copy paste of that, not too much of different. But in 2017, almost anything and everything has a time bar, and not attending them brings in a deeming effect also. So I don't know whether to talk very generally like that. We have to go into each of those time bars, why it is being kept, and which item are we talking about, and then go into the depth of it. So I'm sorry, I think this is not the topic which we should be taking now.
Okay, that's fair enough, but I will just point out, because some of these questions are being asked by members, if you do have time bar questions about your contracts, please make use of our members' LinkedIn group, where you can get the collective knowledge of the membership body. All right. Plug.
It also gives me a lot of energy now to start working on a time bar based.
Yes.
Probably that can bring in more attendees. Although yes. I think we've seen around 300 people today registered, and about 180 or so at any time. Now almost reduced to 100 people plus.
Yeah. All right. The next one is definitely about notices. Beyond the basic requirements, can you recommend best practices for contractors to ensure their notices are clear, comprehensive, and properly documented to avoid disputes later?
I have a suggestion. I think here, if anybody can check in Google, Andy Hewitt, ICCP, while the ICCP list of members were shown, Andy Hewitt had come out with a notice provisions on FIDIC Rainbow Suite. And that give, about 70 notice provisions are there in FIDIC generally. Most of these are, probably one or two numbers here, there, but 70 around. And each notice provision is not just detailed, but they are given examples of the letters, how those notice provisions should be initiated. And those sample letters are provided in Andy Hewitt's book. And I think if anybody is interested to read that, you should have a look into it. Especially, it is very good for people who are practicing this, because they are not just talking about notice provisions. They are giving an example, a letter format of each notice provisions on how to address those matters to the employer or to the contractor.
Yes, and if you are a member, this was asked by an anonymous attendee. If you are a member, some of those notice letter templates are available in our template library. even if it is not the one that you are looking for, you will get some examples that you can see the content of that book. And he will be very happy to know that Mansoor has glowingly described his book today. So thank you, Mansoor. All right, the next question, kind of about claims, kind of about notices. Can I reject the claim blindly if the contractor did not follow the timely manner in submitting the notice, even if I know the contractor is entitled to the claim?
FIDIC says, it can be rejected. But then when the DAB is brought in, and if you can justify that there was a reason why this claim was delayed, then DAB can overrule those timelines, like how we talked about. But you have one side, you have a FIDIC contract where if that is being the substance to governing the contract, then you have to follow what it is written there.
All right. And the final thing, Rajesh has not come back to give a specific question about clause 6. So I'm sorry. But the anonymous attendee has come back to say, notwithstanding my comment that I have a difference with one of the answers, this has been a very interesting and informative presentation. Much appreciated. And I've had another thank you so much added to the Q&A box. So thank you, Mansoor, for all of your detailed information. And again, thank you to your assistants who helped put together all of this information for the ICCP audience.
Thank you, Jen. I hope you will be publishing all those 10-part series of the FIDIC Gold, notice questions on the FIDIC Gold Book 2008 in ICCP, as well as today's video you might be publishing someday. I hope so.
Yeah.
Thank you
yes,
so much.
and let's see.
Thank you all the wonderful participants. Really appreciate it.
Yes.
Many of my friends around the world I know, from Kenya, from Ivory Coast, from Guyana, from Suriname. I can see those numbers, along with people from Kuwait, India, Maldives, and so many other countries. Great participation. Thank you so much. Really appreciate it.
And thank you so much, Mansoor. And again, thank you everyone for attending today. As I said at the beginning, if you requested information when you registered, you will be getting some additional information. And if you would like to watch the replay, or if you would like the slides, those will be available on the website sometime later this week. All right, everybody, thank you so much for attending.
Thank you. Thank you.
All right, bye.